This is Tex from thctrust.org. If you haven't already done so, I encourage you to visit our website, which you see on the screen right here, and then come down here, click this button, and create a new account, and it's free. Today we're going to be talking about some in-depth blueprinting and legwork that you will do to resolve a mortgage matter, for perhaps if you're in foreclosure, particularly if foreclosure is on the horizon, or even if you're not in foreclosure but you want to pursue a strategy to remove encumbrances so that you can have your property free. This is what we do at JAS Association. That's an organization I'm a part of. So if you're looking for foreclosure help and you really don't have the time to do the research yourself, and you have between $3,500 and $5,000 to invest towards your situation, email Anthony at jas.management. Again, that's Anthony at jas.management, and he can tell you what different services we offer. And this is for more of a hands-on approach, with your situation. So again, but please respect our time. We have a team of individuals that's working on this, so you have to have a minimum of 3,500 to 5,000 down, and everything will be negotiated. You can have all your questions answered. Also, another situation that we are dealing with is credit card debt. If you have high amounts of credit card debt, 15,000, 20,000, 30,000, 40,000, and you're interested in reducing that debt or getting rid of it, contact Anthony at jas.management. And I work with these gentlemen directly. I am a part of JAS Association, but you have to go through the proper channel. So if you're a member of thctrust.org and you just have some questions over the content that we're discussing here today, then you can contact me. But what we're discussing today is a lot of the infrastructure and what we do in the background for our mortgage clients, but it's not everything. I'm studying under one of my colleagues and mentor who's had a lot of success with mortgages in court, outside of court. He's beat attorneys, and I've seen the dockets. So you're getting some very in-depth, advanced information. You may not be able to comprehend and follow along with this unless you're an advanced student in this whole endeavor of study. I would say a good prerequisite for this is you should kind of check the last video that I did when I was talking about trusts and equity and the securities regulations and laws that they're using to administer the blind state, or what you guys may call the agency, the straw man, or whatever. That's a good prerequisite, because that's just kind of defining the trust and the equity law, and it's defining the securities law, and it's defining who the positions are, who the parties are, such as there's beneficial owners, there's trustees, there's secured creditors, and you have to comprehend that. Because what I'm finding, having been have been on many talk shows, many of you guys know about that. I've been on internet radio with all kind of gurus that have their different methods for dealing with foreclosures. And just to be honest with you, most people can only just delay. I'm not going to say delay the inevitable, but they can stop the foreclosure. But we're looking for a permanent situation, and these are the things that we're offering permanent solutions at JAS Association. But anyways, what I will say, this is what I wanted to get at. Trust and equity. A foreclosure is an equity proceeding, and there's some admiralty tied in there too. A lot of us that are presently in court, or we have been in court, a lot of times we are bringing in arguments that's based on our rights and our rights toward the enforcement of contracts, and we're trying to disqualify the servicer or whoever is trying to foreclose. We're trying to disqualify them based off of the fact that they don't have the proper standing, or they haven't met the proper requisites to be able to foreclose. Unfortunately, although those points may have validity, when you're dealing with a trust and equity proceeding, there is not really a requirement for the trustee to verify and validate the claim that is being brought before him. For example, the foreclosure claim. So I'm saying, without understanding trust and equity law and knowing the verbiage, knowing the words, knowing how they're proceeding, we'll be arguing about the wrong things and we won't be able to hit those results. So again, the majority of everything they're doing is equity proceedings and trust proceedings. You have to understand those proceedings in order to have a real chance at a remedy, because the successes that I have seen only have to do with the person exercising what they know based off of trust and equity. So those are the things that we're going to look toward today. However, before I touch on these things, because I know those are advanced topics, and I'm going to have a lot of templates that I've put together to deal with certain things in the equity and in the trust area of things. But I want to talk again about another mortgage solution that is not as advanced, and it's something that, for whatever reason, you may want to consider it. This is not one of the solutions that we are using actively. I've used it before, and I'm talking about the quiet title action. But reason why I'm discussing this is because I do know that some people need immediate help to prevent from losing their house, and there's not many people out there who do have success. If you're a do-it-yourself person, I feel if you're not really abreast in securities and trust law, and you can't grasp well, let me just put it like this. This is an easier solution to implement, or at least you can buy yourself some time or potentially win. That all depends on how much you know. With the common law quiet title proceeding. Now, when it deals with mortgage situations, the quiet title action is the only proceeding that I know that that is a common law procedure. So this would be based upon your rights in the property, and not so much um, equity proceeding. So it will operate differently. Now the problem is when you want to do a quiet title action, you have to do a little research, because it's not going to be, the instructions and the clarity of the procedure is probably not going to be easily defined in your state codes, because they don't want you to do common law quiet title actions, because by the nature of you getting into that type of proceeding, you have divested the court from all the authority to make judicial determinations, kind of, I guess you will, or like for them to just kind of roll over your rights. This is a different type of proceeding. So without going, let's click under this mortgages menu down here. See that? So we'll click here, and what you see here is this, the first thing we talked about. This is still good technology. I've updated the presentments, the documents that deal with this. If you want to know what the Mortgage Satisfaction Act is about, you can watch this video down here. But know that this is something that you will incorporate in your overall strategy. That's one of the things I'm going to talk about later in this video. You have to create a blueprint or an overall strategy, and you got to keep notes, because really what I'm learning is to defeat these foreclosures, you got to kind of look more at your estate, because all of the equity proceeding, everything they're doing is a matter, it's a matter of liquidation that's taking place under one umbrella, and that umbrella is your estate. Everything that they're attempting to do is based off of powers that you granted. So that's why I was saying you have to blueprint this out, because when you see what's taking place in a foreclosure, there's there's paying agents, there's a trustee, there's a secured creditor, and there's certain things, and you can basically alter who the parties are and who's entitled to what by your registrations and recordings on the record. Now let me kind of try to define and explain that. And again, as a prerequisite, you should go and watch the last video that I did, and I was just talking about trust and equity in commerce. And I was trying to explain how, when, say, for example, you're in a foreclosure proceeding, they are doing a equity proceeding and an admiralty or a liquidation type of proceeding. Now, in theory, you have already reached a 90 days worth of default. Now this is under trust law. So this is when they're sending you debt collectors and letters of the such. They are presenting you, well, let's say as a servicing agent, because they're an agent. Anytime you hear agent, it's an agent under your estate. So they're the servicing agent for the bank, or for they're a servicing agent for the so-called lender. And the lender is actually the trustee under the mortgage deed indenture, if you will. So when you're dealing with a servicer, he's a servicing agent servicing a contract, and he's not doing it for you. He's doing it for his principal. His principal just happens to be a trustee under the indenture to which you are the grantor. Now, so if you follow what I just say, then you could to some degree understand how the servicing agent, although they may or may not know, indirectly is servicing a mortgage deed for you, which you're the ultimate principal. But in reality, the servicer is operating off an assignment. He's received powers by an assignment from a trustee. And the trustee received powers from you in a security deed where you gave a power of attorney. So you know that they, when they hit you with the foreclosure letter or whatever, they're always talking about they're acting off of powers. So I'm trying to demonstrate for you to see, okay, these are powers. Now, granted, this is an equity proceeding, so when you get into the court, they're filing a certificate of this, a certificate of that, and next thing you know, you're getting foreclosed on, even though you're demonstrating your rights and all of these different things. But the key that I want you to go back to is that I was saying, when you deal with liquidating claims under the equity and trust law, the trustee doesn't necessarily have to validate the claims. Why? Because by the time it's getting to the trustee, there's a 90-day continuing default that occurred, because that default occurred when it was being presented to the company and the company didn't pay. That's the presentations that were put before you as a paying agent. And during that 90-day process, that was the time for you to challenge, who's entitled to what, challenge their entitlement. And not only challenge, but correct those matters in the record, whether it resulted in a breach of trust, removal of trustee, appointment of another trustee, assignment of beneficial ownership and interest. All of these things I'm saying is equity proceedings, but the only way you can establish who the parties are in the equity is by your common law records, which is affidavits, memorandums of trust, certifications, and certain ideas. And the other thing I was saying is, before you get to the equity proceeding, you already have to have the problem resolved, because that is not the type of proceedings for you to challenge the claim. It's only about business. It's only about liquidating the claim. The challenge should have already taken place, which is on the record. So this is why you have to have the matter resolved before you get to your foreclosure. Now, if you're already in the foreclosure, then what you have to do is you have to correct the matter in the common law court of record and direct the proceedings towards the resolution. But I'm finding that arguing about the rights and different things is counterproductive when you're in an equity and trust proceeding, because you're an agent that's in a continuing default, and there's really nothing to argue about because that's not the nature of those type of proceedings. So that being said, before we get into today's subject matter, the reason, that's a tie-in here, because under this menu right here, the mortgages and foreclosures, these are advanced topics down here where you see the templates for premium members, the mortgage blueprinting, which we're going to talk about. But this stuff deals with the record, and you got to look at your administrative, where is it at? Administrative procedure with this. Administrative procedure, you should be studying that with this stuff right here. The Mortgage Satisfaction Act, right? You have to pull this stuff together and see how it works. An administrative presentment process, administrative procedure is important, because this is how you challenge and establish the record of fact, so that by the time you find yourself in an equity proceeding, you can have all the parties and everything set up the right way so that you can win, or so that you won't even find yourself in the proceeding because the matter is already adjudicated on the record. Again, I know I'm kind of saying a lot, Some people will catch it, some people won't, but hey, all the reference material is here so you can go back. Anyway, this is another important thing. We just talked about it. Now, I have, of course, you got to get these templates under here for the premium members, but this is another video. This is the strongest position that I think you can take to prevent a foreclosure outside of what we are doing with trust and equity law under JAS Association. And again, if you're interested in those service, email Anthony at jas.management. And I'm not saying just us, I mean anybody that's actually doing equity proceedings and trust proceedings. But this administrative procedure and quiet title action, this stuff doesn't incorporate that. I put this stuff on the website first before I was able to absorb this information the way we're operating now. So what I am saying is this is all good information, but I have to come back here and I have to update these administrative procedures to establish very specific things on the record that will result in our future objective, which is winning and getting our property free and clear and all of that. All of those, all of these things that you wish to establish that are going to save your property are going to be things that's established in the record. So even though this isn't updated, if you go through this material, keep in mind that what you are doing is you're doing an administrative presentment using the notary and the non-response of the parties that you're presenting to establish specific facts on record. Those facts that you are establishing are facts that prevent them from being able to come in and assert any type of claim of title on your process. So your administrative procedure has to be written in such a way to establish every fact that you will need to get a judgment for quiet title action. To remove, your administrative procedure should be directed at removing any encumbrance from your property by the presentment, the opportunity to challenge, and the default of what an administrative procedure establishes. Now, again, I said this stuff has to be updated because again, if you guys been on the mailing list, and if you're not on the mailing list, you really should get on the mailing list because there's a lot that you're missing. But I've been talking about, and I've been making updates. I'm going to update it on the site. You will get it under, I believe, administrative procedure. I'm going to put another link there, but notary certificates. And I have to do because these things are for specific. So I have to do a video to share with everybody to make them more meticulous and more precise in the usage of notary certificates. Because there's, but I'll just tell you for now, affidavits are for the court of record. So they're important. Certificates, by definition, are verification that a thing has been done or proof that a thing has been done. Certificates, evidence of indebtedness, also is another definition of a certificate, but these are the things that they use in equity and commerce. They use certificates. On the court of record, we use affidavits. Certain certificates, known as involuntary certificates, have to be proved, such as, let's say an example, a certificate of a consent judgment or a certificate of default. That would have to be proved. How would you prove a certificate of default? It'd be proved by looking at what is in the record. So the certificates that are used in equity, they have what's called mandatory certificates, or excuse me, they have certificates required by law, and then they have voluntary certificates. A birth certificate would be a certificate that receives instant credit in equity because it's the one established and required by law. A consent judgment that you built off of your administrative procedure with a notary certificate is a voluntary certificate that can receive credit, but it must be proven. So what I'm trying to demonstrate for you is you really don't ever want to have a certificate of service where there's not an actual affidavit of service. Because if that certificate needs to be proved, there must be a record to prove the certificate. Now, don't take that too far. I was just using that as an example. You may not need an affidavit of service. You could prove the certificate perhaps by the PS 3811, which is the green card and the signature from the post office. But the point that I'm making is Equity is looking at certificates and evidence of debt, and that's how they manage the whole money situation to facilitate commerce in the absence of substance-backed currency, right? But on the other hand, uh, as I said, certificates, some of them have to be proven, and that is what has taken place on the record. So I'm trying to correlate with you before we go into talking more about equity and trust and different things we can do to fix these mortgage situations. I want to show you and demonstrate how important it is that you understand how the court of record or how the record plays into this, even though they're operating in equity and admiralty laws when they're doing these foreclosure proceedings. If you've corrected the record the right way, you would never make it to the foreclosure. Now, that's a big thing that I just told you. But I want you to see how they play together. Know that I'm going to come back and update this to make the administrative presentment even stronger, and so that I can address who all the parties are on the record so we can fix the foreclosure by fixing things on the record before we even get to that type of level. But also what I wanted to reiterate on the certificates, there is sworn, so when I have to update the notary certificates, I want to do a video where I talk about affidavits versus certificates, kind of how I just addressed. Affidavits are how you correct things on a record, dealing with your property rights, your rights under the common law. Certificates are acknowledgments of those rights in equity. So there's a relationship to them, but you got to know the difference, and you got to know that you're going to have more results when you're using the certificates in the equity proceedings and the affidavit on the record. Another thing that I wanted to point out is that these affidavits, or not just affidavits, but memorandums of trust, deeds, conveyances, anything that we put on the record is how we demonstrate our rights, because rights always deals with property, right? And if you have rights, it's going to be a matter of record. If you don't have it on the record, you're already losing by the time you get to court. So what I was saying is understanding when to use a notary acknowledgement versus when to use a jurat, and you know, and also understanding when a witness is required on your deed. I'm going to tell you straight up from my research, you want to have a witness on every document that you are, or every instrument, let's properly call it, that you're creating. You want to have a witness on it, because that's really your counter signer. Now, preferably, I think not only do you want to have a witness, you perhaps want to sign as an authorized representative and have a witness that's a co-trustee or someone signing in that capacity, or just have that witness sign as an authorized representative too. Because what's happening under the trust and equity law is a lot of times you assign something and it'll go to a trustee and they'll countersign it and negotiate it as the trustee for that instrument. So we're now operating with competency, getting the value for our instruments and things. So anyways, when I get into notary presentment templates and I do the update here, we're going to talk about the affidavits versus certificates. We're going to talk about the sworn declarations versus unsworn declarations. We may talk about the difference between verifying, certifying, declaring, because these are all things that you can do on your affidavits and on these certificates, and they mean different things. We have to talk about the notary protest, and we got to talk about certificates of service, certificates of non-response, and the indexing of those certificates. Why do we have to talk about them? Well, as you guys know, I'm very meticulous. I've looked at a couple of indexing and recording manuals, which are these are those high-level manuals that the clerks actually go off, that are they are available if you ask for them, maybe from Freedom of Information Act or something, but this stuff isn't readily available. But I think where I'm at, and hopefully where you guys are going, we're going to master this stuff to where we know more than those recording. That's where I am right now. So we want to know that when we're bringing an affidavit, although it's something they've never seen before, that we've crossed every T, we've dotted every I, we have the proper certificate, the proper verbiage is there, we have a witness where a witness is required, and we do all of these little things so that we can get the expected results, and that there will be no resistance and they can't invalidate anything we're doing. What I was getting at the record, about the record, that I didn't really say yet, is that by my research, most of the things when they reject you from filing something, the majority of the time there is something. Actually, every time that I've seen, including my own work, there is something that's allowing them to reject it. But they're not going to tell you that because they don't want to give you the solution so you can give everybody the solution. Um, I think I have the solutions because I don't really get rejected when it comes to filing things. And I mean things like affidavits of beneficial ownership. But there is definitely some high level scrutiny. Sometimes it may take 24 hours for them to go through all of their regulations to realize, okay, yeah, the shit's done the right way. So I'm not saying that to discourage you, but I'm saying if you're going to use notary certificates, I'm going to suggest that you don't use a notary certificate of non-response ever, unless your notary handbook or your notary manual provides for a notary to give such a certificate. Most of them will provide that it's authorized for the notary to do um, a notary protest. So only do a notary protest. You can do an affidavit of non-response and an affidavit of whatever. And the affidavit can have a notary certificate recorded on it if you ever needed to use that in equity, or it could even be a certification provided into the equity proceeding by a trust. Certification of service. You know what I'm saying? But the point that I'm making is I don't think you have to do certificates of service and certificates of non response. I don't want to get off the subject, so just know that stuff is coming up. And I've already created the template, so it's not going to take long. I just got to put the templates in there. It'll make your administrative procedure stronger. If you want some coaching, that's one thing that I can really coach you well on. If you are doing an administrative procedure and you want to bounce it off of me and you want me to give you some things to give your administrative procedure teeth so you can reach the objective that you're going for, then contact me and we can do that. All right, so we kind of laid out here. These are the older ways, but again, the one other thing I'll say about this administrative presentment: when you're doing these presentments, you're removing clouds on the title, so that when you file, because see the thing about a quiet title action, it is a common law proceeding, requiring that party to come in with the contract, which would be their mortgage deed, because that's the only contract that they ever come with. That is the segue into the whole mortgage situation from your servicer, the mortgage contract. So again, if you're going to do this administrative presentment and you're going to do a quiet title action, I suggest you do a rescission of signature on the deed. You do your administrative presentment, whatever that results in a signature, a rescission of signature, so that you can nullify and void out the contract because they're not going to challenge it. You want to cancel and void that contract by page and book number of the original by cross-referencing it and rescinding the signature on it and letting that cure and marinate so that when you do go into the quiet title action, you're really forcing them to have to come in and state positively by affidavit why they have a claim in a property and why your rescission is invalid, and they can't really come in saying by powers granted to them under the mortgage deed when you've canceled the mortgage deed. So again, you put all those things on the record, and then as soon as somebody shows up in your quiet title action, you object, you file a motion to strike, and you try to get them kicked out for failing to record an affidavit to qualify their interest in the matter and failing to bring a bona fide contract for bringing false fake paperwork that's not verified or genuine or authentic, right? The same type of things that they do in statutory world, you can object to that and you don't have to let that fly in a common law quiet title action because that is not the procedure. Now again, common law quiet title isn't going to be talked about. You're going to have to dig and do some research, but at the end of the day, I think this will buy you a lot of time if you have to go that route. Now, that's not what we're really going to get about. Now we're going to get into the subject matter. Once again, if you have high credit card debt and you're looking for a solution, or you have a mortgage situation, whether you don't have any problem and you just want to be free and clear, or whether you are in court. Now, we're going to start lightening up on in-court people because that takes a lot of our resources, but it's a reality. So even if you're in court, or if you just, the best situation where we can help is when things are not out of control yet, but it's coming. That gives us a time to do what we need to do to address the appropriate things on the record. Again, if you're interested in those services, Anthony at jas.notary. management. That's who you will email. Now, I'm going to take a breather real quick. We're not going to go anywhere. It's just going to be silent for a little bit. I'm going to take a sip on my tea here, take another little puff of my joint, and then we're going to go down here to mortgage blueprinting. And this is what we're going to talk about today. All right. We're not ready to go yet, so just gather yourself, go get you something to drink. Okay, first off, we're not really starting yet, but I want to say big thank you for those who support our organization, whether you're actively supporting or whether you ever support it. This information that I'm about to drop on you right here is very advanced, as you can see, and this is coming from your donations. I know why you guys are working the 9 to 5. You created the circumstances. You've invested in this research, and this is why this belongs to you, especially the premium members. So even if you're not a premium member, you're going to learn something from here. If you are a premium member, you can come in and access these templates. These templates are part of the structures that we also use. I'm not saying that this is all we use, but these are part of the structures that we use when we take on your situation and we create a blueprint and we go execute that blueprint. Our goal is to kind of take the stress off of you. So if you do invest in those services, the ideal is you're gonna pretty much let us handle every aspect of your mortgage situation, in court, outside of court, the debt collector letters, everything. All right, so bear with me. We're gonna get cracking here shortly. In the meantime, I'm gonna roll this down here so you can kind of look at what we're gonna be doing here. I like this little diagram. I created it. Let me kind of explain what it is here, and I'm gonna explain from my understanding what is taking place in a foreclosure. And I'm going to have to take some positions here. These are positions that a lot of people who fight mortgages and things, they don't take these positions. I'm going to take some very distinct, clear positions. And I'm not saying that you have to do things this way. More importantly, you got to create a blueprint and execute that blueprint. You have to know what solution you want, create that solution, illustrate that solution, and then go execute every document, every template, every action necessary until you're only left with what it is you designed. And you really have that power. We all have that power. We just never knew how to use it because we didn't quite understand that everything was operating in trust and equity. So we didn't know how to write deeds, how to appoint trustees, and all these different things. And we fell under the delegation of laws of the United States, or we fell victim to being pimped out by or being exploited by those who do know what's going on and those who do know how to work these structures at our expense. So at the top here, you see the grantor. That's where you are in this whole thing. When someone's foreclosing on you, as I said earlier, they are a servicer. The servicer is servicing a contract for your lender who's not up here. So he doesn't really work directly for you, and your lender is the trustee for you. So indirectly, the servicer is servicing a contract for you, but he's like two parties disconnected from you, which is why he can bring you into an equity proceeding like a debtor, and everything you're screaming about you being the grantor has no merit there. Because it's trust and it's equity law, but they're in a liquidation proceeding. So there's no real purpose for the grantor. The grantor does have an opportunity to fix the matter, but it can't be done in the proceeding. It has to be done on the record. You see what I'm saying? So that's why we start with the QWR. People know what the QWR is, so I'm not going to really go into that. And then, because they're never going to respond to the QWR properly, and they're never going to respond to the statement of accounting, and they're never going to respond to, um, there's some other things I wrote in the QWR about the initial accounting and the accounting that they're supposed to give you for the promissory note. So when they do these things, they're in default. They're in breach of the trust. What trust are we talking about? We're talking about the trust under the security deed, which is a trust. And there isn't anything that says it's irrevocable to my knowledge, right? So, and again, once again, when a servicer begins to foreclose on you, if you notice the letters that even come from the attorney, they're talking about the powers that were granted from them. You got to follow the train of powers. The powers comes from the trustee assigning powers to the agent, which is the servicing agent. Anytime you hear the term agent, know they're always operating under the same name. They have different agents' names, but this is all on your estate. You're the authenticating agent at this point, and you can put on a hat and play different roles because remember, you were the grantor too when you signed the security deed. But of course, they prepared everything to you, and then you authenticated it as an authenticating agent and left it at that. So we start by sending the QWR and asking questions. It may not just be a QWR, it's everything that you've done up to this point where they've totally ignored you. These are the grounds of a breach of trust. So then you'll hit them with the breach of trust for many things. And we're going to go through the diagram so you'll see. I'm just kind of going through that. Once you hit them with the breach of trust, a part of the breach of trust is what I have here is satisfaction and or revocation. What I meant is somewhere in between here when you're dealing with the servicer, you will revoke the powers of their trusteeship for them breaching the trust by not doing what they're required to do, and you may have to appoint another trustee, right? This is what we have right here. Appoint a new trustee. This is a new trustee. Um, This is getting into the transfer of beneficial ownership. See, we know liability is in the owner, right? And this is how the servicer gets at you because you are the owner and you are the debtor under the contract that he is servicing. You are also the grantor, but in the equity proceedings, he's not dealing with you in that capacity. They're dealing with the trust instrument, and the servicer or the receiver, the trustee, gets all the rights. So, in order to deal with them as the capacity as a grantor, you couldn't do it in this area anyway. It's just too many different relationships going on here because it's more than just you as the grantor of the original trust and you as the debtor under the servicing contract. There's all types of other contractual relationships that prevent you from just easily prevailing in the equity proceeding. So that's why after you breach, now here's another thing, and this is what you learn when you start to study trust technology, that indenture technology adapts to things in real time. This is why, as the grantor, you need to know how to write a proper assignment, how to rescind your signature, how to establish a breach of trust on a record, revoke powers, appoint, because this is indenture technology. This is operating in trust because your rights are on the record. This is where you correct the record so that because trust me, before the servicer or the trustee or any of these people that are liquidating claims against the estate, they go off of a checklist on the record to make sure that they have these powers and authorities which come from various different places. The main one being the power that was originally granted in the security deed to the trustee, which was passed on to the servicing agent. And remember, you're an authenticating agent and you're also a paying agent. That's another relationship. So they have a different type of trust relationship. Not only are you the debtor under the contract, if you're looking at the security deed, but even under the securities law, you're the paying agent in default. And the court clerk is now the trustee because the servicer who was servicing a contract came in for a secured creditor, found you in a 90-day default, then he was automatically converted to a trustee to liquidate that default. But then he took it to the court and assigned the whole claim to the court and now the court became the trustee. You're still the paying agent for the company, to which the court is the trustee for. So that's another relationship, paying agent in default. Said all that to say, you want to default them. So remember, we were talking about fixing everything before you get to that area. You want to already have the breach of trust on the record, the revocation of powers, which is key because this is one of the things they look at to get the power to foreclose against you. And you want to make sure this is indexed properly so that there's no ambiguity that they were noticed and they know that they can't act like they weren't noticed. So you're looking at your faxes, your registered mail, recording in the record, and everything else. One other thing, that's why I was saying I got to do the lesson on the notary certificates and the trust instruments, because recording is an issue for some people, but that's because they're not doing their instruments properly. When you know when you know the requisites of what need to be in an instrument, you're not going to have a problem getting these things recorded. So sever the relationship based off of the breach of trust, and now we want to assign a new trustee under the contract, because when we breach in, because we're really the QWR and the breach of trust, I'm saying the servicer is really a servicing agent. He's an agent for his principal, which is the trustee, and the trustee's principal is the grantor. So you're going to kind of do the breach of trust. This is going to really, so you send the QWR to the bank, not so much the servicer, even though you see it here, so excuse me. You're going to do some debt collector responses, but this is just to give you an idea. But the breach of trust and the QWR, all of that's going to go to the trustee. Then you're going to appoint a new trustee. This ABC Ambassadors Trust represents a private trust. What I mean when I say a private trust, it's not incorporated as a business trust with the Secretary of State. There are no articles filed with the state. The only evidence of this trust is a certification or a memorandum of trust or whatever assignment record that occurs right here ends up in the county recorder's office. Now that is going to create some things in the background, some updates in the recording. So what we're doing is, like I said, we're doing these different things to correct the record so that we have a chance to stand in the equity proceedings. But one of the things that we're doing, and there's other things that we're doing, but I want you to understand, out of the many things that can be assigned and transferred in a deed, we're not just transferring property, because that don't mean nothing, right? There's different types of property, especially when you're dealing in equity. There's beneficial ownership. And although beneficial ownership is, how people say ownership is responsibility. Yes, when it's all in the grantor. But now you can assign out the beneficial ownership. You can assign the responsibility. You can assign the principal interest, the legal title, the equitable title. And all of these things mean different things, especially in equity. But there's no proof that you made that assignment unless you have a public record of assigning these different interests, such as beneficial owner. Who the beneficial owner is important in equity. Who the trustee is important in equity. How can you show up with powers held in trust when there's a record of a breach of trust and a removal of trustee powers and evidence of a different trustee under the indenture? And that evidence comes from the grantor, which is the same authority that they use when they say they're foreclosing based off of powers received. The thing is, when you're in the equity proceedings, they can't see you and they can't hear you. That stuff must already be on the record. So you see where we're going with this? So notice, after we breach the trust and all of this to get this first trustee, who you don't see here, out of the picture, which consequently knocks out the servicer too, we want to do a new assignment, right? Now this is a private trust. So now I'm going to kind of leave that at here. I'm going to zip through the rest of this real quick because it'll take me forever to get through these advanced topics. But we're being very meticulous and careful about what is being assigned in this deed, because we're going to assign the responsibility, the principal interest. What is the principal interest that we're responding? That's the money that you never got back for the promissory note that you negotiated. We're going to account for that. And I need to go back to the top and explain a couple of things when we get into the templates, which we're going to do. But this right here is the second assignment. This is going to be a private assignment. Remember, after you breach the trust, the first assignment is going over here. This is what's going to show up in a deed, the recorder of deeds. There's going to be a record that there's a new grantee holding the property. So now if these servicers and these guys decide to foreclose, they're going to be servicing you, and of course they're going to be serving this person, because they're always looking in the record to figure out where their powers are and what things lie. So they're going to serve this person, which is a private trust. Now, many of you guys know you can appear in court to represent a private trust, but it's more beneficial, and your rights is something different about how they handle the rights if you appeared as an executive officer for a corporation that had limited liability with insurance. So this private trust has a trustee, and its trustee will use a public LLC as a receivership or as a trust or whatever. That's kind of advanced, but you'll see what we have here is he's holding the private equity in trust, but there's a trustee who's and mind you, there's going to be no record that this trustee actually holds this, because when you look in the property, you're just going to see the one assign you're going to see the assignment, the one that was there from the grantor. Then you're going to see another assignment going from the grantor to the grantee. But once they start sending out foreclosure paperwork and things, if they do, you will respond from the limited liability company receivership with a power of attorney, because they're going to be like, well, who are you? Then you're going to have to say, I'm representing the interest of this private trust, and you're coming in with the power of attorney. And they really can't ignore you at that point when you're a public corporation with rights, property recorded in the state, and you're holding title to property. And you don't really understand all that yet because we didn't go through the templates and we didn't go through the blueprint. I guess I got to kind of lay it out here in layers. I know I'll be doing another video of this. You might not get all of this, but I guess this is enough that if you're a premium member, you can go in here, study it, grasp it, look at the templates, and then by the time I come out and do another video on it, it will sink in. Because right now, to get this in the beginning, we're talking about equity and trust proceedings. It's a lot to grasp. But again, you know, if you don't want to be doing this, you know, by yourself, contact Anthony at jas.management, and you will see the different services that we have and see what we have that may be able to assist you. Okay, so blueprinting. That's what I wanted to talk about. And I'm gonna try to get through this as quick as I can, because I know this is just like an introductory video to these advanced solutions that we have. This is a particular blueprint that I'm using, right? We like to blueprint a situation, and you should too. Meaning, especially if you've been dealing with the mortgage situation for a few years, you have to see where you are now, and you have to create where you want to go. A lot of times people are looking for a solution, but they don't mentally know what a solution looks like. They never looked at what needs to be on the record, or what doesn't need to be on a record, or what needs to be in place or does not need to be in place to create the situation where my property is just free and clear and there's no one threatening to foreclose. So you got to be able to backward engineer. You got to first see what got you into the position. Then you have to create a blueprint to take the present situation and bring it to the situation that you foresee that allows you to be free and clear. So in order to do that, you first have to understand something about title registrations, liens, encumbrances, and where does the authority come from for someone to have a security interest in your property under this present foreclosing environment. Now, I'm going to take some positions here, because I believe if you don't take the proper positions when you're dealing with where they're getting their authority and how they're operating in these foreclosure proceedings, then you can't correct the matter. And if you're arguing about the wrong thing, so here, let me just get straight to the point. One position is that they never gave you a loan, and that is not their position. So there's never a need for you to really argue about the fact that they didn't give you a loan. That has no place in the equity proceeding. You may argue that somewhere, but that will be when you're dealing with things on the record. You may establish certain records based on the fact that you were never given anything of value. But when they're doing their proceeding in equity, they're not acting as if from the presumption that you gave them a loan. Although on the surface, that's what it seems that they want you to think. They're doing a liquidating proceeding and they're operating as a trustee, um, liquidating the claim against property that they're holding, which is a promissory note, because as the paying agent, the company is going in a 90-day continuing default. So look at it that way. Really had nothing to do with the loan because you're dealing with a servicing agent. He's there dealing with a servicing contract, which is, remember, I was trying to show you before, that's disconnected from you as the grantor. So they're already dealing with the default. The only thing that you could try to prevent them from coming in the first place, from coming in by having corrected on the record that they were not the proper trustee, so this guy couldn't possibly be a servicer. Just to kind of give you an idea. But anyways, one of the things we have here is the rescission of signature, especially like earlier, if you're going to quiet title action, you want to cancel out that mortgage deed. The mortgage deed is where they derive all their powers from anyway. So this is the contract. You may do a common law process that that leads you up to the active rescission. That could be based off of being deceived, misled, into thinking that you were receiving a loan. Now, with this rescission, that's something that you're doing on the record. So you're not going to be arguing that, but that might be the basis upon which you rescinded the contract. When you rescind the contract, it's a page and a book number recorded. So at that point, and I just clicked this rescission, at that point, and you're going to cross-reference the original contract, right? Notice I say affidavit of rescission regarding security deed, cross-reference, ABC County Recorder book, whatever, page, whatever. That's the original deed that you're cross-referencing. Once you do the affidavit of rescission, which is this right here, they'll put a new page and book number up here. That's a matter of your common law record. Now it's on the record. And it's good to do an administrative procedure first because, you know, you'll show that you've given the lender and the trustee, you've given them notice and you've given them time to challenge, and then you changed and correct the record. An affidavit of rescission is an action that that has an effect on the cross-reference security deed. So now you're canceling the validity of the deed. So that's kind of important on both ends. But anyways, the reason why this is here is I'm not saying you're going to always do that, but many people have already been fighting mortgages for a while and they're already at that point. But anyway, this is a template. It's a really good template. Maybe I can read through it real quick. Affidavit of rescission regarding a security deed, cross-reference the page and the book number. That's important. Let's see what else is important. Remember what I was telling you before? Notice how I got, this is an instrument. And I know that we're dealing with trust law, so I'm signing as the authorized representative. You know, it's by John Doe. That's the company. I'm the authorized representative because I know that they have me down as the authenticating agent. I'm authenticating this instrument and I'm having it attested or a counter signature right here on it. Okay? And then you want to put the jurat on it, right? Why is it a jurat? Actually, yes, it's a jurat because it's an affidavit of rescission. So we're going to put a jurat on it. It's an affidavit. And then we'll get that recorded with the page and the book number. Okay? So here's the next most important thing that we're going to talk about. Since we're dealing with securities laws, we're going to talk about the affidavit of beneficial ownership. The only place I've heard about an affidavit of beneficial ownership is Minnesota Rule 220 and various places that talk about securities laws. Now, I know people think ownership is liability. Yes, it is when it's in the hands of a debtor, so to speak. But anyways, yeah, I want to stick to the point. So, when a trustee receives an affidavit of beneficial ownership, that's a claim against the collateral that he's managing, and it requires him to do certain things under trust law. So this is why this is important. What are we the beneficial owner of? Let's click this real quick and look at this template. We are talking about the promissory note. I don't have the promissory note here, but if you look in your mortgages, in your mortgage package or whatever, what's recorded in the county, you'll see the security deed, but you usually won't see the promissory note. And the promissory note was taken out of your hands. You wasn't quote unquote given anything for it, but since we're dealing with equity, we're not going to start screaming fraud. If we want to scream fraud, we correct all that on the common law record. But in the equity proceeding, if we're going to, and I'm not saying you have to do it this way, I'm just sharing with you, looking at it from an equity standpoint, what they did is they took that promissory note that you signed and you didn't give them any instructions with it. They went and invested it. So they went and invested it, and they are making money off of it because as trustees under trust and equity law, they get paid for every transaction, every securitization, whatever happens with that note, they're getting paid off of it. But they're not touching the principal because the principal belongs to somebody. Now, the crazy thing about it is you may think the principal belongs to you, and it does belong to you, but not automatically. You have to claim it. And if you don't claim it, you fall under the default trust laws, which basically means that principal interest is going to be invested indirectly by a whole bunch of government and public trustees so that they can make off of it, and you could be a debt slave, right? So, this is what the affidavit of beneficial ownership is. This is the first thing we have to do to claim a private interest. So let's go back to that original transaction where you signed a promissory note and it was deposited. The definition of deposit, when you look at it from a bank's perspective, is the unpaid amount of money. That means that's what they have to give you back. So they took it and they've invested it and they fractionalized and it's still being invested. One of the things that we do before we do this affidavit of beneficial ownership on our principal, which is basically the par value, the face value of the note, that is the principal. This is the thing that people do the OID on. We're just not doing it with the OID at this level. We'll be doing that too. But at this level, we're putting an affidavit of title on the actual note. Reason why you have to look at that other video, that's why I said it was a prerequisite when I was going into the trust and the equity things, because then you will understand how every, you know, everything in equity relates to real estate. So everything in equity, all the certificates and claims are going to be indexed to real property, real estate, or a person, or a legal description of land. So this is again why it is important for us to have that promissory note in there, because for example, your warranty deed is in there that allows people to attach liens to your property, right? Your warranty deed is in there. Well, let me put it like, let me give you a different example. When you read the trust and securities laws, they basically tell you when you have like a promissory note and you don't have an affidavit of title on it, or affidavit of beneficial ownership, or a certification of trust, then it's just a security that's out there. And anytime someone needs to make a claim against it, they get converted into a trustee after you go under the 90 days of continuing default. So they can run this stuff up into court. And your first level of protection is putting an affidavit of title on the principal interest. The security that you authenticated. Remember, you're authenticating agent. So you authenticated a security with that company trade name on it, right? Affidavit of title, that's the grantor move. It's happening under the common law. Why do we got the tracer flag on it? Just to tell you in a nutshell, anything that you're doing when you're building when you're building a security, how can I explain it? Like any type of private security that you're building on the record for the purposes of being recognized in commerce and in equity has to have the tracer flag. And that's what we're doing with the principal interest. What that is it's private equity. So it's a security and it's titled, but it's not governed under securities such as stocks and bonds and the public side. It's bundled in some type of public security. So it's managed under private laws. That's where the affidavit of beneficial ownership comes in. those private securities laws. So what you want to do is first you want to have a page and a book number on the county, right? Because that's where the asset is. But we have the tracer flag because the asset is basically it's an account that you're building based off of your right to the entitlement to the principal in that instrument. So it's a claim, if you will. Anyways, what else do I need to say about this? Okay, once again, what do we have? Remember, this is an instrument. So authorized representative, countersign, and then you want the document, the notary down there. Anyway, there was something else I was going to say about this. Oh yeah, so the QSIP search results. Yeah, we go do that too. So actually, this would be attached to the promissory note, and you can get this recorded in your accounting. I've done it. So, hold on here. So that was the affidavit of rescission. All right. Now remember, we was just looking down here and we talked about starting out with our blueprint. These are the things that we're doing in the very beginning, because you don't want to just breach them. You don't want to put them in a breach of trust. You want to give everybody due diligence. I mean, that's going to be the end result. So the first thing you do is you respond to them. They send you something, or better yet, they haven't sent you anything yet. You hit them with the QWR. This is a very long QWR. Oh, come on. Well, as you can see here, look how long this QWR is. It is long. Long QWR, and it's not asking them for just no BS. I went through this, and it's asking them. I didn't just create this. I snatched this off the internet somewhere, and then they've tried to make it unavailable. You can't really find this, but it's an excellent QWR. So it's long, and they're never going to answer everything in it. And it's not just asking for nonsense. Almost any line you pick out of here is asking for something that you would rightfully be entitled to. So the fact that they're not going to answer that QWR, I also have a response. This is an interesting response right here. Let's look at this. This is a response to the debt collector. You know, they send you that communication. Well, look at this response. You respond via certified mail. Please find the enclosed articles. One is a letter dated whatever, attempt to collect the debt, request for validation. Okay, this is your cover letter, so this is not what you're saying. But you're also giving them the notice of rescission. So you're responding to them, because when they send you the debt collector letter, they're saying that we got this power of attorney based off of your security deed, whatever. You're letting them know that that deed has long been rescinded. Now, this is important because they're required to respond to you under the Fair Debt Collections Practices Act and under the Consumer, the Dodd-Frank Act and all that. They're not just required to respond to you in accordance with the FDCPA. They're also supposed to respond to the other meaningful questions in communications. What we're particularly asking them with this debt collector response is, let me just read it. Because the important thing is we have a rescission of signature on the mortgage deed contract. They know that's in that record, but they didn't even address it. They're going to just kind of act like it's not there. So here's an example letter of what I sent. Dear Mr. Gooding, I am in receipt of your letter dated December whatever, wherein you allege that as of whatever date I owe $48,000 to ABC Bank National Association. Based on the facts on the public record as recited herein, the security deed is not valid, and therefore I challenge the statement in your letter wherein you allege the debt is owed to ABC Bank National Association. I demand proof of claim that I owe a debt. This constitutes actual and constructive notice of the record. On or about August 28, 2014, I rescinded my signature from the mortgage deed. The fact of rescission is recorded in the public record on book whatever, page whatever, filed in whatever county office at whatever at 3 o'clock p.m. For the reasons stated therein, I demand proof that I owe a debt. ABC Bank was given notice prior to the rescission by United States Postal Service First Class Mail and did not object. ABC was given notice after the rescission by USPS First Class Mail and did not object. John G. Gooding, the same attorney that I'm dealing with, was given notice of the rescission on September whatever by email at the address listed on their website as well as their whatever address, and they did not object. The result of the rescission cancels the security deed and affects any powers of delegated authorities of ABC Gooding LLP, the servicer, or other assignee under the now rescinded security deed. In consideration of the history of your non-response to my letters, I'm affording you this final 30-day opportunity to provide a valid dispute to the facts of the record and validate the accuracy of your contract and the debt that you are alleging I owe. This letter should also be construed as a request for debt validation, FDCPA 15 U.S.C. 1692. I am affording you this final opportunity to provide a valid dispute to the facts on the record and validate the accuracy of your contract and the debt that you are alleging I owe. In the event that you do not respond or provide an improper response to the facts stated on the record, I will immediately request, demand, and order that you cease and refrain from all communication on this matter. I reserve my right to further challenge the authenticity of your claims that I owe a debt. Actually, I'll also let him know. So anyways, they ain't going to respond to that. That was a cold ass letter, right? But they're going to keep it moving like they do. And then that's when you hit them with so that was your QWR. You hit them with the QWR. You responded with the FDCPA. You hit them with the whatever else you hit them with at that point. And then you're going to hit them with something right under the securities laws, which is a call for redemption of the note. I don't have time to go into that, but let's just say this is something that anybody can do. Notes are supposed to be redeemed. How many of you guys have ever redeemed a note? How many of you guys has issued promissory notes in the world? So I got this redemption notice based off of securities laws. And also when you study trust and equity, there's also something known as a paying agent, which is what you have defaulted to. That's the position that they have you in by default. But you have to understand that the paying agent, you can't pay for anything. Anything that you're required to pay for is an obligation of the United States. So even if you were to pay for something, this is where your proper banker's endorsement would go into effect. You would pay it to the order of the United States Treasury based on their obligation to you. Their obligation to you would be the laws that you cite in that banker's endorsement. But based off of now we understand the trust structure that they're operating under, I say just appoint the CFO or the other fiscal agent that you're dealing with, appoint them as the paying agent and let them deal with the matter. Okay? So here's something that you would do to the trustee, the person holding the property. So since there is a trustee under the indenture, the public side of the note, I say you serve them, the CFO of whatever bank that's acting as the trustee under the security deed, you serve them with the notice of redemption, and you also serve the fund manager to where that promissory note that you authenticated, that private equity security, it is titled and bundled in some mortgage-backed security. You can get the CUSIP number of that and find the fund manager. He's the asset manager, and I will also CC him on this call for redemption. Now, these are dealing with federal laws, and it's all up their alley. So when you do these things, you don't really have to worry much. Look up a call for redemption. It has to have certain things in here. I'm going to explain something. By my research, you redeem something for a par value, but then there's a conversion price. And my research says that that conversion price is about, that's the amount of how much a Federal Reserve note is in accordance with $1. So when you issued those private securities, those were not United States dollars that you issued. That was private money, if you will, and it was negotiated or invested and fractionalized into the U.S. monetary system. When every time a security is converted, there is some type of conversion rate, and it's based off of something. So naturally, to me, the conversion rate would be that money has to be converted. It was converted into public money, so it's got to be converted back into a private type of money, which has a different conversion rate. So public money being Federal Reserve notes, I believe is 42.22 par value to the dollar. So that basically means when you call for redemption, unless somebody can show me where I'm wrong, you're redeeming it for the face value, but then you have to, the conversion rate is that face value times the value of the United States dollar, which you'll find that under the Warsaw Treaty, which they never really wanted to identify the value of the dollar. They tried to avoid it, but they did, and that's what I'm asking for. Now, the other thing is, no one really challenges you when you do these things. When you put an affidavit of claim, you have to declare the amount. When you call for redemption of the note, you have to declare the amount. One of the things that you're going to understand, that I'm beginning to understand, is a lot of the affidavits and the records and the declaring that you're doing is the creating the accounts of the entitlement that you're entitled to. Part of the reason why you wasn't ever able to hold the equity is because you never kept proper books. This is why we're getting into trust and equity law. But anyways, here you see it. Dear Mr. Johnson, in addition to this call for redemption on the reference note, you have been appointed the paying agent and are hereby requested in order to redeem the enclosed note, number, whatever. Now remember, you're going to have a page and a book number on this note, so you'll be able to identify it by page and book number if you recorded the affidavit of title on it. But you also have the QSIP search results if you had the QSIP search results. Anyways, you're saying, because that's another thing, in the notice of redemption, you're supposed to put the QSIP number in there, right? Even though, and you don't have to make any representation to the accuracy of the QSIP number, but it is supposed to be in there. This comes under the securities laws. Look at those resources that I put under the trust and equity menu. But anyways, we're asking him to redeem the enclosed note and settle any outstanding claims against ABC Bank. He's the officer for that bank. Settle any outstanding claims against the bank in consideration of the following, laws. And I give him the discharge laws, the HAR 192, whatever, and all of that stuff. And some other important laws. You got to go in there and read the stuff. But the thing is, what I'm asking them to do is, you guys are both trustees. Don't try to foreclose and take the property because of a continuing default. Call for the redemption on the note. Stop the investment. Stop whatever you're doing. Pay out the claim against the principal. A redemption of the note is serious. So anyways, that's the next thing we're doing under this structure. And now we got to hit them with the breach of trust and removal of trustee. That's because they didn't respond to the QWR. They didn't respond to the debt collector stuff. They may or may not have responded to the redemption of the note. In that template, I told them to make sure that the proceeds from the note, they have to go into this receivership, or the new trustee, which is actually, the receivership is the public company right here. This is the trustee for the new, this is the beneficial interest managing organization for this new trust, right? So this trust is now the trustee for the grantor, and this trust has a trustee. Every trust has a trustee, which is this public organization. Anyway, that's advanced. I don't want to get into all that. Hopefully that people can understand this structure. If you're already kind of nice on this type of thing, you can understand these structures and you can follow along. But then anyway, we want to hit them with the breach of trust. Notice about this breach of trust here, how I always notice this one. This one, I have it set up as a county. It's actually an instrument, is what this is. So it isn't. It is written. It's an affidavit, but I think, how do we do this here? Yeah, this is an affidavit. I got to change this because this is an acknowledgement down here, and it should be a jurat. I still have the witness, but we're gonna do a breach of trust. It's an affidavit regarding a breach of trust. It's got to cross-reference what? The original security deed, because that's a trust. We want to remove the powers of the trustee and a revocation of the trustee powers. We want that instrument recorded. So now, do you see why it's important? Because they're looking in the record before they do these equity proceedings, because they're coming in saying that they are certain people and they're getting these powers from the record. So anyways, we're going to hit them with the breach of trust, and now when you remove the trustee, you got to appoint another trustee. Now, something else that I felt to, okay, here's the new trustee that we're appointing, but I'm going to skip over some of that. I want to go into this assignment real quick. This is something else that's going to be important. I can't go into it because yeah, this should be updated. This is not the proper instrument. But anyways, what you need to pay attention to in this assignment, and then I'm going to close out here because this is getting longer than I want it to be. But again, these resources are here. If you're pretty savvy with mortgages and things and you think you can pull this off, you can just do a coaching session with me. If you're a premium member, you have access to these templates, and maybe you can affect some of this. If you would like assistance and you have 3,500 or 5,000 down to invest in your situation, contact Anthony at jas.management. But this is the last thing I want to say, and this is important for you to understand. This is a deed of an assignment, something that you would record or that you could record. There's different things going on in this deed. I, John Doe, the grantor of whatever address, this 5th day of February 27 for the sum of $10. Why is this number important? Because usually when you do these type of deeds, you have to run a tax assessment on this deed. And if they don't tell you to go up to the tax assessor's office, you should go up there, have them run an assessment on the deed. If you put $1 million, they're going to assess you on $1 million. You put $10, they're going to assess you on $10. Because there's a transfer taking place, and there's going to be an indexing where the grantor, right now, if you look at the situation, you're the grantee on the security deed. So we're doing a deed of assignment. This assignment will come after you've breached the trust and all of that. Some of that would be on a public record. Some of it would be on a private record. Now we're doing a deed of assignment. This deed of assignment has multiple instruments in here. I hope you can see the security deed, where the contract has been canceled and rescinded. Whatever remnants of that is going to be assigned to this new trustee. The old trustee has breached his obligation. And I know somebody may say, well, that sounds like you're contradicting yourself. If you did a cancellation on that deed, it's just totally not invalid, so you shouldn't be assigning it to another trust. I get that. I've considered that. And, I don't want to really kind of argue that back and forth. And it is something that you can go, I think, both ways on. I decided for different reasons to still assign any outstanding responsibility, liability, or title under that instrument to another trust. Hear what I said actually. Notice that for the sum of $10 and other good valuable consideration, we do hereby convey to ABC Ambassadors Trust, the trustee of address, all rights and title responsibility, right? Because there still may be some responsibility under this canceled deed. Beneficial interest, because there is some beneficial interest because these things were invested. They were invested for principal value and the listed instruments. So beneficial interest in these instruments and the securities and real property attached to. So there's a couple of things. I'm transferring rights, interest, and title and these instruments as whatever they represent, chattel paper, and the real property attached thereto, which includes the real estate, which has this legal description. So I'm indexing a lien against my property on the common law record, but I'm also establishing who the trustee is, because ABC Ambassadors Trust is now receiving the title, the interest, and everything in the security deed. Also in the rescission of signature as it relates to the security deed. They're receiving all the responsibility, the rights, the title. This allows the grantor to bow out of the situation. Now, the affidavit of beneficial ownership, we talked about that. Here it is. That is also recorded in the record. This represents title on a principal interest. So this security interest now has title. We want to register that. We want to assign that principal interest, that face value. Remember, we did a redemption on this for par value. Whether they gave it to us or not is one thing, but it's irrelevant because we're going to capture that on the UCC, and that's going to be titled and held. And we're going to use that to negotiate. This gets real deep. The solution, the solution ends up in, let's see if we have time to talk about that. But anyways, I wanted to point out that there's a lot of different things going on here. This assignment is on the public record. this assignment, if done correctly, will cause an update in title registration, meaning anyone trying to foreclose will now have to contact and notice ABC Ambassadors Trust, because they're now a responsible type party, interested party. They hold beneficial interest in everything else. Now, the key thing, what I want you to realize, is that the promissory note, the principal interest, that cannot necessarily be negotiated by the grantor because of his different type of relationships, such as like the debtor under the servicing contract. He can't negotiate that note because that servicing contract and things that are written in there prevent him from discharging the obligation in a certain way. This is why he's doing an assignment of this affidavit of beneficial ownership attached to a note. And the note is an asset. That's why it has a page and a book number in the county. He's assigning that asset to a trust, who also is an interested party now, because if this trust receives a claim of a debt outstanding, it could either challenge it or it can offer this security. It can offer this promissory note, which is valuable consideration, and it has a value worth more than whatever a potential debt can be. Now, this is a private trust, again, remember, so anything that this private trust will do will be answered by a receivership trust, which is a public company, and that will be showing up with the power of attorney for this private company, and it'll be showing up with the UCC in hand and the proper authority to negotiate this note for value to discharge the obligations. That's where we're going with this, and it will be accepted, because if it's not accepted, then we have to go to court as an interpleader and open up an escrow account so that the court can liquidate the principal interest in the promissory note. Because remember, the call for redemption has been done. These are very serious plays, but I guess I really can't explain to you in this short amount of time how serious of a play it is. And I hope that I'm, piquing your interest, especially you guys that are advanced, to go into equity and trust and begin able to and learn how these things are operating, learn where your remedies are. So this was the overlay. The next time I come in here and talk about this, I'm going to just jump right in and go through this process like you already understood everything that I just laid out. So again, go here to get the background before you try to go under here and understand all of this. I did a video about this last week. Uh-oh, I got logged out here. Let's try to get back in. I'm closing out, by the way. And I was saying, go here, Trust and Equity and Commerce, get an understanding how this stuff is operating. I put a lot of references here: Securities Exchange Commission Act, Trust Indenture Act, the 1983 MSI. I put some other things here so you can understand who these parties are, you know, what the difference is in real property, real estate, personal estate, who the parties are in these blind trusts, agents, paying agents, authenticating agents, secured creditors. Go there and get that background. And again, if you would like some direct hands-on assistance, you can email, the email is up here also, anthony@jas.management. And we're dealing with high credit card debt. You need to get some of that credit card debt discharged. Doesn't matter. You know, we're helping someone with $60,000 right now, and they're getting good results. So there you have it. I wish I could have went further in depth, but as you see, this video is long, and we still didn't touch everything. So thank you for watching. I hope you got something out of it. Join the premium membership group.